Okay, I'm going to call this Board of Adjustments meeting on June 8th, 2022. Before we get started, we are missing one board member. I suppose we need to get an alternate seated. So,
Yes, sir.
which one of you two fellows are up next? Okay, come on up. Mr. Farley will take Christie's seat. Okay, we've called to order. We've filled the vacant seat. No old business. New business is a variance. So we'll let the planner introduce that, if we will.
By the way, since this is my first Board of Adjustment where I'm actually participating, I'd like to say thanks for having me. My name is Matt Kirkland. I'm the new Planning Director for the town of Oak Island. You have before you the only item of business under new business for today is a variance request for a side setback encroachment on 1730 West Dolphin Drive. Before we get started, this is a quasi-judicial hearing, meaning that the board should make its determination based on impartial evidence heard in the hearing. Speakers would need to be sworn and subject to cross-examination for questioning. We do have a couple of conflict of interest questions we usually go through right before one of these meetings. If it's okay, we can go through those with everyone.
Go for it.
The first, does any member of the board have a financial interest in the subject matter at hand? No? Has any of the board members engaged in ex parte discussions? This means discussions with the applicant or staff outside of the hearing about the subject matter? No? Has any of the board members conducted a site visit to the site for the purpose of evaluating for this hearing?
Let me disclose something in a moment. I live at 1722 West Beach, which is just across the street and 3 houses down from this.
Okay.
And I discovered on my walk yesterday a sign in the yard that was going to be before the board this morning, but that's been my exposure to it. Okay. I have no pecuniary interest in this at all.
Okay. Do you feel like your site visit prejudiced you in any way prior to this meeting?
Just let me know that it was coming before the board.
Any other board members? No? Does any of the board members have a close or familiar relationship with the applicant? And is there any other reason that you cannot have an open mind and deduce based on the evidence that you hear in this hearing today? No? Okay. I would like to go ahead and enter the agenda packet, page 2 through 18 for this hearing into evidence, which is the agenda packet you have before you. So this request is for a variance into an encroachment into the required setback for a proposed elevator. Property is located at 1730 West Dolphin Drive. The corner lot setback in this instance that applied is 10 feet. That being said, the UDO does have a carve out for elevators, mobility, or cargo lifts on existing residential structures, where they may encroach 5.5 feet into the required rear or front setback. I'll also point out that this Board of Adjustment has the authority to vary any dimensional standard of the ordinance as long as the findings of fact are met. So while this refers to a front or a rear setback, this board can vary any dimensional setback as long as it meets the findings of facts required for the case. You have on page 4, a diagram of the existing structure and the proposed 6x6 elevator. As you can see in that diagram, the existing structure takes up essentially the whole lot. So it will be noted that our proposed elevator would require a variance no matter what yard it was placed into. The board does need to find 4 findings of fact in order to grant a variance. That needs to be a 4/5 determination by this board. I'll cover those very briefly. I would recommend that in any motion this board takes to grant or deny a variance, that we address each of those findings of fact within the motion so that we can make sure that those were addressed properly. The first is that an unnecessary hardship would result from the strict application of the ordinance. It is not necessary to demonstrate that in the absence of a variance, no reasonable use can be made of the property. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstance, as well as hardships resulting from conditions that are common to the neighborhood or the general public may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. The hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with the knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. So if you buy a piece of property and you know you might need a variance in order to do something, that is not self-created. And then finally, that the requested variance is consistent with the spirit, purpose, and intent of the regulations such that public safety is secured and substantial justice is achieved. You have in your agenda packet the applicant's addressing of those 4 findings of fact. They're also here in the audience. We can get everybody sworn in to provide additional testimony at this time, if that's all right with the board.
Very good. If you folks, I suppose, are the applicants, if you intend to speak to this issue, if you'd be sworn in by the clerk, if you stand, please. You can do it remotely.
Raise your right hand. You solemnly swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth.
I do.
If you want to make an opening statement of sorts, I have all the information I believe that you wanted to convey to us, but if you'd like to address the board, it's a fine time to do it.
If at first, if the applicant had any questions for me about the summary I gave before the board, do you have any questions for me about what I presented to everyone?
Does the board have questions for me?
We'll get to that.
Come on up to the podium.
As long as they're my first board meeting.
That's fine.
Your name and address, please.
You want my home address or?
Your name and address, please. Yes.
Okay, my name is Betty Pope, and my address is 1730 West Dolphin Drive, and Oak Island. And basically, when we bought this place, everything was fine, but then my son was in a horrible car accident, a head-on collision about 3 years ago. It's going on 3 years, and he has not been able to walk since. So we wanted to put in an elevator to help him come enjoy the property as well, because if we can't get an elevator, we were talking about probably selling and trying to find something that had an elevator. I don't know. I'm not sure we can afford something that already has an elevator. But he is disabled, and we could not have foreseen this accident.
Right.
So that's basically you've got in front of you what I had to say, but I'm open for questions if you have any.
I don't have any. Does the board have any questions?
I have a question. Is the elevator that you're going to put in, well, let me start. The house itself has got 2 stories, two
Yes.
floors, and the elevator is going to serve both floors?
Right.
And is the elevator going to be enclosed?
Yes.
Okay.
It will have the same siding as the house.
Same siding
Yeah.
as the house.
Yeah.
All right, and you'll be able to access it from the underground park, or the underhouse
Right.
parking?
Right.
Okay, I think that's all the questions I have right now. Thank you.
Any other board members have a question for the applicant? Mr. Planner, did you have something to add?
I do not, no, sir.
Okay.
Unless you have questions for me.
No, we've been down this road before.
I think they met all the requirements.
Well, before we start deliberating, we need to close the hearing.
Yeah, well, I move we close the hearing.
Second, all in favor? Hearing's closed.
I have one
Okay.
comment.
Go ahead.
The American Care Act, basically trumps all these other things, so without question, the variance should be granted.
Okay, then you want to put that in the motion? Or
I put
do
that
we
in the
have to
motion.
specify each individual requirement
It would be best for the record.
for the record? Okay.
Record.
Let's go through those. First of all, unnecessary hardship would occur without the addition to the elevator. Does anybody?
I think that is clear that without an elevator, there would be an unnecessary hardship in this case, given the situation of the family here.
Okay, number one's affirmed. Second, it's necessary and appropriate to accommodate the handicapped. You went over that, so that kind of meets the second one, I believe. So let's get those in order so the clerk has them down in order. Yeah. Second, the hardship results from conditions that are peculiar to the property, such as location, size, topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions, are common to the neighborhood or to the general public, may not be a basis for granting variances. I think the very first sentence of this is what we're dealing with. The hardship results from conditions that are particular to the property. I found it particular that the side setback prohibits this particular action or this particular project to be taken on. So that's my reason for it, peculiar to the property. Anybody else want to add to that? Number three, the hardship did not result from action taken by the applicant of the property. I believe that's self-evident.
Yes.
Okay. Number four, the request variance is consistent with the spirit, purpose, and intent of the regulation. The regulation is to keep people from bunching up on each other. That's what setbacks are for. Special circumstances do arise that require variance to deal with those type of problems. And I think this meets the challenge.
Yeah, and I would want to note specifically that the ordinance in speaking about elevators in setbacks particularly mentions that the Board of Adjustment can consider variances to setback requirements for elevators. And so I think that this clearly meets the spirit of the ordinance.
It does. The ordinance has made provisions for this variance to occur. So I think we met that, and you're right there. It is spelled out. Your ADA comment, I think we still have to go piece by piece by piece, but I believe that's the topping of the cake. So without further ado, do I have a motion?
Motion, we approve the variance.
Second? Second. All in favor? Unanimous. Okay, folks, good luck with your project.
Thank you. Thank you very much.
Move to adjourn.
All in favor?
This is a record, you know that. What, it took 15 minutes?
Possibly so.
13.
All right, thank you, folks.
Thank you,
Appreciate it.
gentlemen.